Welcome back to another episode of the Law Schoolers podcast, and we are going to be talking today about criminal procedure searches in a reoccurring context. This is a broad category, and so we are going to break this down into several episodes. And for this category, this episode in particular, we are going to be talking about searches in recurring contexts of people. We, in other episodes, are going to be focusing on houses and workplaces, schools and prisons, conducting an inventory search, searching automobiles, and so on and so forth when it comes to, as well as the use of technology in conducting these searches. So let's talk about persons. In persons, we are going to be focusing on searches incident to arrest, and then also full body searches at the jail. Those are going to be our two main things. A search at the very beginning, and then a search at booking. So what is a search incident to arrest? Well, when the officers make an arrest, they are free to conduct a search incident to arrest. This just simply means that the officers can conduct a search within the scope of the arrest to remove any evidence that might be connected with the crime. Few cases here. First case, Birchfield versus North Dakota. Our rule is that officers may search a person in the area of their immediate control without a warrant when they arrest a suspect. The whole point of this is because it prevents the destruction of evidence, and then it also protects the officer. This rule is going to apply even if there is no reasonable suspicion, probable cause, or the presence of a weapon. So that's a pretty broad scope. Search incident to arrest, you don't need reasonable suspicion, probable cause, or anything else. All you need is that you can search the zone within their immediate control, and you don't even need a warrant to do that either. The whole point of that is to protect the officers. So let's look at a couple of examples of how this works. You've got State versus Huffnagel. Huffnagel, in this situation, the officers obtained an arrest warrant for him for possession of drugs. As the officers arrested him, Huffnagel glanced to his nightstand, and the officers then searched the nightstand, which was about 10 feet away from Huffnagel at the time. So now the question is the nightstand within the scope of the search incident to arrest? Well, now we need the definition of what the zone of immediate control is and how far that extends to. The zone of immediate control is going to extend to the zone where the defendant could have reached immediately before the arrest occurred. And the purpose of this is because we don't want to incentivize any delays in an arrest. Because if you think about it, if the officers are approaching, and if the officers see him glance, and they don't arrest him then because they want to conduct the search before, because once you put him into handcuffs, well, then it's going to be harder to say, oh, this is within the zone of immediate control, because what are you going to do? His hands are tied behind his back, and he's 10 feet away from the nightstand. So if you're going to be arresting him, you don't want to have this delay. And so the officers, this zone of immediate control, the definition of it extends to right before the arrest actually occurs. How far could this person have reached before the arrest could occur? That's going to be the zone of immediate control, at least as it goes by space. Legislatures are obviously free to reduce the zone and establish the timing of the zone as well. So let's talk about People versus Boff. This is going to address the zone of immediate control by time. The previous case was about space. This one's going to be about time. What happened here? The officers saw Boff, and they saw him leave a particular farm that was growing drugs. And so they arrested him, took him to the station, and there they searched his backpack several hours after the arrest had occurred, and they did so without a warrant. So what's our rule here? Well, the rule is that the search needs to occur at the time of arrest meaning search incident to arrest needs to happen at that time unless the item could have been searched at that time of the arrest, meaning the item was within that zone of immediate control as the subject was being arrested, and it is immediately associated with the person. So what is something that is immediately associated with the person? This is going to be a backpack. This is going to be a purse. And this is going to be a briefcase or whatever else it might be. Typically, something that the person is going to associate with themselves as part of, so to speak, their identity. So, if you could have searched it at the time and it's immediately associated with that person, a search can occur later. And so in People versus Boff, the backpack that Boff had searched, this falls within the scope of that reasoning. Okay, let's talk about one more example. This is State versus McCrane. McCrane or McGrain? One of the two. I can't tell if that's a G or a C. But after the officers lawfully entered a home because they had an arrest warrant, they saw McGrain, we'll say that's a G, McGrain, being a little fishy upstairs, fumbling around with the curtain, assumed that he was hiding something. And so McGrain came downstairs, and at that time McGrain was arrested because that's who the arrest warrant was for. At the time of the arrest, the officers then went upstairs pretty much to see what the subject was up to at that point. And they discovered drugs upstairs on a coffee table that was being prepped for sale. So they found evidence of crime. So under the original rule, this is going to be outside the zone of immediate control. Now, there is something that is called a protective sweep. The officers are able to go and search the areas that are adjacent to the defendant and the rest of the house where there's a reasonable suspicion a person could be present that could potentially endanger the police, and specifically a person with a weapon. So a protective sweep requires reasonable suspicion that another person who is potentially a threat to the police is going to be there. Now, is this a protective sweep? The answer is no. This is not a protective sweep because there was no suspicion that there was another person upstairs with the defendant at the time. So, this falls outside that zone of immediate control. This is not a protective sweep, and so this is a search in a reoccurring contents that should have been not conducted, and so evidence related to that search can be excluded at trial. Okay, so that's searches incident to arrest. Let's talk about body searches at the jailhouse. Maryland versus King Jr. outlines our rule, and it says when a search is made without a warrant, the court is going to weigh the interests of the government against the subject's expectation of privacy that they have at the jailhouse. The more intrusive the search, the heavier the state's interest needs to be to have conducted that search. So what are some of the interests that the state has? Well, the state has a legitimate interest in knowing the identity of the people that they arrest, making sure that they arrested the right individual. They also need to make sure that if they didn't know the individual before the arrest, that this person isn't wanted elsewhere. And so they also want to make sure that they can recapture this individual if this individual is going to flee. So this interest that we have of identification of the individual, along with the minimal intrusion of a DNA swab, because a DNA swab is just taking a Q-tip, swabbing it against the cheeks as you're being booked, and putting that on for testing. That, along with the minimal expectation of privacy when a person is arrested, that was enough to justify a search here without a warrant. So, let me just clarify that to make sure that you know what exactly happened in Maryland versus King Jr. King Jr. was detained, taken into custody, and part of the booking process, they do two things. Did a fingerprint test, and then they also swabbed him for DNA. The DNA results came back several weeks later, and that's really a big reason why this is an issue, and this DNA connected him with a crime that had been committed previously. And that is what King Jr. is actually being charged for, is that previous crime that had gone unsolved but is now solved. So now it's a question of whether or not that DNA evidence was an unlawful search, and if it was unlawful, then it should not come into trial. And the officers are saying here is this is a minimal intrusion. A DNA swab isn't a lot, and you don't have a lot of expectation of privacy in the jailhouse. And then also you have the state interest of knowing the identity of the person if they're wanted elsewhere, and to recapture the person if they should flee. But the dissent in this case is going to argue that this is an unlawful search, no matter the circumstances, especially because this statute, in this case, that purpose of the statute was for investigatory reasons, which investigatory reasons are going to normally require a warrant. And it's not only for the identification reasons. This reason, in addition to the fact that the identification actually didn't even happen until 4 months later. It was months later. I don't know if it was exactly 4 months later, but that shows that the state's interest in that case is going to be significantly diminished because the stated interests don't actually line up with what was being said. So what's our takeaway here? Well, the officers are authorized to conduct more invasive searches when they end up booking individuals in the jailhouse. And this can actually include more invasive searches such as strip searches and also inventory searches as well. Inventory searches referring to the personal belongings of the individual. Okay, we have one more case. This is just one case to illustrate this example of what we've been talking about. So, the officers conducted an arrest in a home, and in that home, they conducted a strip search. They did that upstairs at the time of the arrest, and from the strip search, they discovered additional drugs. So, what's our rule when we are doing a strip search? Well, an intrusive body search outside of the jail may be conducted if there's going to be a warrant, unless there's an exigent circumstance. And two, there's a clear indication, this is even more than probable cause, that the contraband is present on the person. And there is a third part too. It says that the test must be conducted in a reasonable manner. What's going to be reasonable typically is going to be same gender officer as the subject is the one conducting the search, and as respectful of an environment as one can be in that kind of situation. In this case, People versus Moore, all three of those elements was lacking. This was done in a home. There was no warrant. There was no exigent circumstances. They had probable cause, but not a clear indication that contraband was present when they conducted the strip search, and it was conducted in an unreasonable manner. I do want to note that this is the rule for conducting a strip search in a home outside of the jailhouse. This rule does not apply when a search is conducted in the jailhouse. That is something that we will talk about in a few episodes. So, that's searches of people in a reoccurring context. We talked about searches incident to arrest, what the rule is there. You've got the zone of immediate control, and we talked about that zone being limited by space and being limited by time, how those limitations are going to be. And then we talked about body searches at the jail and in the home as well. Body searches can be made if they are minor, weighing the interests of the state. And then when they come regarding strip search in a home. We talked about the 3 elements there, and these are different from searches incident to arrest, while inventory searches at the jailhouse. All right, that's where we'll leave off. Next time, we are going to be continuing our discussion about reoccurring searches. We are going to be focusing on houses and workplaces. And houses are a very special place that are afforded very significant Fourth Amendment protections. And so that should be a fun topic. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is, if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is, if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.